Hi friends, hope you are fine and doing well. I welcome you once again with a new topic called Quashing of FIR. See, the court has been conferred power under section 482 CrPC to do the complete justice. These powers are known as inherent power. The meaning of word inherent is permanent, which could not be removed, and by virtue of it being a court, an office, these powers are so wider that no statutory rule or provision can limitize it. The court basically has to do two things. One is to prevent an abuse of process of law, and second, to secure the end of justice. Now, these two primordial functions which court has to perform and consider so that no injustice take place or nobody should be prejudiced at all. Now, while considering whether the FIR or the complaint should be quashed or not, court has to keep in mind first and foremost thing is the nature and gravity of the offence. If the offence is so serious and it causes threat to the society, or it involves a moral turpitude or very heinous such as rape, murder, dacoity, in general the FIR would not be quashed. This has been pronounced by the Honorable Supreme Court that in a serious offences, because this power is so vital, so significant, should be exercised sparingly and exceptionally only in the cases where an abuse of process of law is taking place. So, court would evaluate whether end of justice would justify the exercise of inherent power or not. So, the power should not be exercised in case of a heinous offences. Now, if the offence is private in nature, because many a times it has been seen that people, in order to settle their rivalry with the opponent, or they are so influenced, under the garb of the extraneous consideration or with the help of the political nexus, they lodge the false FIR. Now, in those cases, the court says that if the predominant element of the FIR or the complaint is civil in nature, then the court should consider the same and quash, means the private litigation should not be allowed to give color of a criminal litigation. Now, generally in the offences such as commercial, financial, economical, or emerging out of the partnership dissolution, which has basically a civil flavor, in such an situation it would be appropriate for the court to quash where the parties have settled their dispute amicably. So, the general principle is that in a heinous and cases of serious nature it should not be allowed, but the cases which involves a element of civil nature or the cases which are basically the private wrongs and the society is not going to be hampered if the proceedings are quashed, then in such cases the FIR should be quashed. Now, yet another reason for quashing is that if, say, victim and offender compromises. Now, see, the point to remember here is that the quashing of FIR could be on the basis of merit of the case also and could be on the basis of the compromise between the party, but it is different from the compounding of offence. Compounding is to be governed under section 320 CrPC, which is altogether a different concept. Few cases which are compoundable in nature are allowed to be compounding, few are with the intervention of the court are compoundable, they should be allowed, but here we have been talking about the offences which are not compoundable in nature. Now, what are compoundable, non-compoundable, cognizable, non-cognizable, bailable and non-bailable, and separate video we will be making for that to have a better understanding on this phenomena. But herein what you have to remember, we have been talking about the cases which are cognizable in nature and not compoundable with or without the intervention of the court. Fine. Now, see, very recently I have gone through a judgment which is very progressive judgment as far as I believe. In a cases of cheating, generally it is seen that a person commits a cheating or defraud the people the colonizer, the people who are indulged into the white collar scam, they usually indulge into this kind of activities, mobilize the deposit from the people and do not give them appropriate return, and once they fail to give the return, they flee away, and later on when they are caught and they are produced before the court and subjected to trial, then they enter into a compromise with the victim by repaying their amount what they deposited. See, in such a cases, the court used to quash the FIR liberally without taking into consideration the fact that cheating has actually been committed, and the economical offences have not only created a great disaster in the life of the people emotionally, financially and psychologically. So, recently I have gone through a judgment, I will name that judgment also in my forthcoming lecture, wherein the Supreme Court has really hit very heavily on the court, saying that in such like cases the compromise should not be entertained or the proceeding should not be quashed. Fine. So, to my view, this is a very progressive judgment and one should go through it, especially those who are into practice and those who have been preparing for the competitive exams as well. State of Haryana versus Bhajanlal 1992 judgment, wherein the Supreme Court laid down few guidelines as to under what circumstances the FIR should be allowed to be quashed. So, the first and foremost thing which Supreme Court has held, that wherein the prima facie case is not made out, means the ingredient of the offence, what is being alleged in the FIR or the ingredients of the offences are not satisfied, or no cognizable case is made out, or during the investigation if it is seen that from the allegations or from the evidence so collected by the investigation that the commission of cognizable offence is not disclosed. So, in such cases the court says that it should be allowed to be quashed. Now, many a times it is seen that one who need to settle his score with the rival using the police nexus or the police nexus, he gets the FIR registered with the only ulterior motive to wreak his vengeance or to satisfy his personal and private grudge. The court should be very cautious in these cases, and if it smacks out something mala fide, ill will or seems to be the malicious prosecution, then court should intervene and quash the proceeding, so that the precious time of the court should be saved and the abuse of process of law or the court should not take place and the end of justice should be met. So, in order to prevent the abuse of process of court and the miscarriage of justice, the person should approach with the clean hands and the clean mindset also. I herein will quote a quote that nobody should be allowed to touch the fountain of justice with the tainted hands. So, a person who is innocent, who has been falsely implicated, who has no the involvement in the crime, and who ultimately proves that he has been victimized and he has been subjected to undue harassment, and all these parameters, if the court feel that yes, from the evidence or from the allegation it has not yet come forth that the person has committed some crime, then in such like cases the quashing could be permitted. So, thank you so much once again for hearing me patiently. I hope I have been able to give you an idea about the cases in which the quashing can take place. Fine. So, thank you and see you in the next lecture.